welcome to the debate. The legal landscape of modern litigation, it's increasingly intricate, isn't it? Especially when you get these allegations of widespread fraud intersecting with public statements from the people involved. Today, we're diving into a genuinely contentious area. This tension between a plaintiff's right to pursue defamation claims for, alleged reputational harm and a defendant's assertion of protection under litigation privilege and these anti-SLAPP statutes.
Right. And our discussion really explores a central question. Can a lawsuit alleging a, quote, fraudemic in the workers' compensation system, along with these subsequent public statements about it, can it truly be shielded from defamation claims by these legal doctrines? This whole debate emerges from recent legal filings concerning a defamation suit brought by Dr. Alexandra B. de Moura and the New York Spine Institute against the Willis Law Group and other defendants.
Exactly. So my perspective today is that these kinds of public statements, particularly when they present unproven allegations as if they're established facts, well, they can cross a critical line into defamation. And this causes significant professional harm that these legal privileges shouldn't just automatically shield.
And I'll be arguing somewhat differently, that these statements, especially given the context of active litigation and relating to matters of pretty undeniable public concern, are in fact fully protected by established legal doctrines like the anti-SLAPP statute and the absolute litigation privilege.
Okay, so my position fundamentally is that the Willis Law Group and its co-defendants, they really engaged in a malicious campaign of defamation against Dr. de Moura and the New York Spine Institute, NYSI we'll call it. And this extended well beyond the legitimate bounds of litigation. I mean, the plaintiff's complaint itself, it clearly alleges the defendants initiated a frivolous lawsuit and pursued a malicious campaign to disparage Dr. de Moura. It even says the underlying RICO complaint's sole purposes were to slander plaintiffs, extort money from them.
Strong words.
Well, yeah. And what's particularly problematic, I think, is the explicit treatment of unproven allegations as established facts in their public communications. This caused severe professional harm. For instance, there was this First Law Group post on LinkedIn. It boldly declared a massive fraud scheme uncovered in NYC involving over 30 medical providers. Just stated it. Then a Fifth Law Group post specifically named New York Spine Institute Dr. Alexandra B. de Moura and said, and I'm quoting here, the allegations, staged construction accidents, unnecessary surgeries, inflated injury claims designed to exploit workers' compensation and personal injury systems, cases like this erode trust in medical providers, and so on. These weren't presented as allegations in that public framing, but rather as, definitive findings of a proven scheme.
Okay.
And crucially, the defendants were, or certainly should have been, aware of significant challenges to their underlying RICO claims. Because a court in a related case, Roosevelt Road Re Ltd versus Subin, had already dismissed very similar RICO claims. Why? For a fundamental lack of standing. But despite that judicial finding, the defendants, they continued their public campaign. They even posted some of the stuff before Dr. de Moura and NYSI were formally served with the RICO complaint.
Before service. Interesting timing.
Exactly. Which to me clearly demonstrates an intent to proactively harm their reputation, maybe coerce a settlement. And the consequences are documented. A potential physician deciding not to join NYSI, Dr. de Moura being questioned by hospital officials where he holds privileges, a clear loss of business opportunities. So this isn't just, robust litigation tactics. It looks much more like a weaponized public campaign.
Well, my understanding shifts quite a bit on that point. I think the de Moura defamation lawsuit should be dismissed precisely because the defendant's statements are protected by established legal principles, namely the absolute litigation privilege and New York's anti-SLAPP statute. In fact, the Willis Law Group's motion to dismiss frames the de Moura action as a, quote, textbook SLAPP action, that's strategic lawsuit against public participation, designed explicitly to chill protected public speech.
The classic SLAPP argument.
Okay. Well, yes, but it fits here. Firstly, statements made within the federal RICO complaint itself, absolutely protected by litigation privilege. That's a very long-standing legal principle. It shields statements made in legal proceedings from defamation claims, because we need, uninhibited advocacy in court. Secondly, the public statements, including those social media posts you mentioned, they relate to a matter of undeniable public interest, this whole fraudemic concept in the workers' compensation system. It's gotten sustained media attention over the past 18 months. That squarely places them under New York's anti-SLAPP statute, Civil Rights Law Section 76A. And that law broadly protects communications in a public forum related to an issue of public interest from these kinds of retaliatory lawsuits.
Okay.
And look, it's vital to recognize that the RICO lawsuits initiated by the Willis Law Group, they are active federal cases. Dr. Moura and NYSI haven't even attempted to seek dismissal in that underlying action. And far from being baseless, these RICO complaints were actually the catalyst for further review by the New York State Workers' Compensation Board. That review led to several other doctors named in similar RICO actions having their authorizations to treat injured workers either not renewed, like Joseph Weinstein and Vadim Lerman, or completely removed, like Jonathan Simahay. Others resigned their authorizations, Matthew Grimm, Meredith Golzad. The board itself even noted that most of these cases came to its attention from a system stakeholder in the context of these very RICO matters. So this demonstrates the allegations are substantive, they've had concrete regulatory consequences, which validates the legitimate public interest. Plus, the Moura complaint, it fails to plead the necessary specificity for defamation claims under CPLR 3116A, that's New York's rule needing specific details, and it lacks factual allegations regarding the malice required by the anti-SLAPP statute.
That's a powerful argument, I grant you, especially the point about the regulatory actions and the public interest angle. However, I want to push back on this public interest justification, especially when you look closely at the nature of the RICO allegations themselves against Dr. Moura. The claims in the Moura action complaint were frankly notably deficient. They consisted of non-specific, cursory boilerplate allegations. They contained no specific facts, only alleging Dr. Moura should have known certain information. And critically, the complaint, quote, does not allege that plaintiffs ever even spoke with any of the other defendants in that case, much less that they agreed to engage together in a RICO criminal enterprise.
Now, presenting such, threadbare claims, as the Moura complaint calls them, presenting those as definitively true in public forums like that LinkedIn post saying massive fraud scheme uncovered, that moves far beyond protected speech. That's active defamation. Another example, the Third Law Group post included a photo of a CEO speaking in front of a sign, a timeline, stating they filed suit against lawyers and doctors for using construction workers to stage accidents. It didn't say allegedly or accused of, it stated it. That implies guilt, not just reporting on a lawsuit, and that distinction is crucial here.
I hear your point about the specificity, or lack thereof, in the complaint against Moura himself, but we also have to consider the broader context. This fraudemic, this alleged widespread workers' compensation insurance fraud, it is indisputably a matter of significant public concern. And that's the trigger for the broad protections of the anti-SLAPP statute. The defendants' RICO complaints, okay, they're extensive, maybe even dense, but they do outline a complex scheme involving dozens of medical providers, attorneys, and others working to inflate the value of injured workers' labor law and workers' compensation insurance claims. And the subsequent actions by the New York State Workers' Compensation Board against multiple other doctors named in similar complaints, where the board explicitly cited the RICO matters as bringing treatment issues to its attention, that directly rebuts the idea these were merely threadbare or totally unsubstantiated claims across the board. These are serious allegations of fraud with real-world regulatory impact that underscores the legitimate public interest in talking about them. The board's own findings provide sort of independent validation that these weren't just, baseless claims being aired without any consequence anywhere.
My skepticism, though, stems from the idea that litigation privilege should just blanket cover all these statements, particularly when the underlying litigation itself is arguably problematic. The litigation privilege, it isn't absolute, right? It doesn't grant a license to abuse the legal process, nor does it automatically stretch to cover every single public statement someone makes. The Moura complaint explicitly argues the litigation was, quote, sham litigation intended to defame and/or disgrace plaintiffs so as to coerce and/or extort payment from plaintiffs. Now,
When litigation is commenced for such an improper purpose, or when public statements are made with reckless disregard for the truth, they shouldn't be shielded. And furthermore, remember, some of the defendants' social media posts were published long before plaintiffs were served with the RICO complaint.
The timing point again.
Yes, which demonstrates, I think, an intent to proactively harm reputation rather than just report on an active legal proceeding. This behavior, combined with the sub-in dismissal for lack of standing, where a court found the plaintiffs lacked the basic standing to bring those RICO claims in the first place, it suggests the defendants knew or should have known their public statements were built on a pretty weak, maybe even frivolous foundation. The privilege exists to facilitate justice, sure, but not to enable malicious campaigns or to spread information that's already legally questionable.
That's a compelling argument about the potential for abuse, but have you fully considered that the absolute litigation privilege firmly protects all statements made within the context of pleadings in active litigation, regardless of the underlying merits, unless those statements are entirely immaterial to the case, which these weren't? And the RICO lawsuit naming Dr. Moura is in fact an active federal case. Now, as for public statements outside the courtroom, yes, the analysis shifts slightly, but they are largely protected as fair reporting of judicial proceedings under Civil Rights Law Section 74, which, I should add, is interpreted very liberally in New York to provide broad protection to news accounts of judicial or other official proceedings. The Willis Law Group's own legal memo notes that even pre-litigation statements can carry a qualified privilege if the defendants had a good faith belief that litigation was essentially bound to occur.
Given the ongoing nature of the fraudemic investigations and all the related RICO actions, the defendants consistently had, arguably, a legitimate basis for discussing these matters publicly. And the anti-SLAPP statute, it's specifically designed to broadly protect any communication in a public forum on a public interest issue. It recognizes that such discourse is vital, even if it touches upon individuals involved in litigation. To restrict that too heavily would really undermine the whole purpose of these protections.
I find that reasoning problematic when we think about establishing intent and, crucially, knowledge of falsity. The defendants, I argue, demonstrated at least a reckless disregard for the truth, if not potentially outright knowledge of falsity. That sub-in case dismissal, the one based on lack of standing, that should have been a huge red flag to the defendants, that their whole theory of RICO liability was fundamentally flawed. Yet, they continued to publicize their claims against Dr. Moura as if they were fact. And the Moura complaint specifically highlights that the RICO complaint only alleged Dr. Moura should have known certain procedures were unnecessary. It didn't assert he knowingly acted with fraudulent intent. That's a big difference. Moreover, the defendant apparently failed to mention anywhere in the 158-page Moura action complaint that the WCB independently determined that the patient's injuries were work-related before Dr. Moura ever even performed the procedures in question. Now, omitting that kind of potentially exculpatory information, that strongly suggests an intentional disregard for the full picture, trying to maintain the narrative of fraud. It demonstrates, I think, a clear intent to mislead the public.
I'm sorry, but I just don't buy that interpretation of intent or malice. Let me tell you why. The plaintiff's complaint, as the defense argues, glaringly and utterly fails to demonstrate any substantial basis to even conjecture that any moving defendants have made statements knowing them to be false or with the actual malice required under the anti-SLAPP statute. And the subsequent actions by the New York State Workers' Compensation Board, they are crucial evidence here. The board's decisions to decline renewal or remove authorization for other doctors named in these RICO suits, sometimes explicitly referencing the RICO matters, that underscores a legitimate, evidence-based concern about treatment and proprieties. These official actions by a state body directly contradict any simple assertion that the defendant's claims were just fabricated and baseless or made with knowledge of falsity. The board's independent investigations, which were prompted by the RICO complaints, they validate the defendant's good faith in raising these issues in the first place. It's really difficult to argue reckless disregard for the truth when an independent state agency, citing these very matters, takes disciplinary action against other doctors involved in the same alleged scheme.
Okay, well, both perspectives have certainly highlighted critical aspects of this very intricate legal dispute. On one hand, we've considered how robust legal protections like the anti-SLAPP statute and the absolute litigation privilege are really designed to safeguard open discourse and, the pursuit of justice, particularly in matters of public concern like alleged systemic fraud in workers' comp. And the evidence you pointed to, the regulatory actions by the Workers' Compensation Board against other physicians, that does suggest a credible basis, at least in the broader sense, for the defendants' initial allegations and their public reporting. It underscores the role these protections can play.
But on the other hand, we'd examine the equally compelling argument that these protections, well, they aren't boundless. The claim that public statements, particularly when they're presented as established fact, may be made before formal service, or even in the face of judicial rulings questioning standing, that they can inflict significant, measurable reputational and financial harm on individuals. The allegations of litigation being used for, quote, extortion or shakedown purposes, and those specific omissions you highlighted in the RICO complaint regarding Dr. Moura, they raise serious questions about the defendant's intent and, maybe, their adherence to ethical standards in public communication. It really highlights how these powerful legal tools could potentially be weaponized, pushing the boundaries.
Exactly. Ultimately, the challenge, as always in these cases, remains in striking that delicate balance, protecting legitimate legal action and public transparency, while simultaneously upholding the right of individuals to be free from false and damaging accusations. This case, I think, really illuminates how deeply intertwined reputation and legal strategy have become. It forces courts to continually reevaluate where that line should be drawn when it comes to publicizing complex, often very high-stakes litigation.
Agreed. There is clearly more to explore in the material concerning this evolving intersection of law, public interest, and ultimately, personal and professional reputation.